Hello, everybody. Let me see something. I just got. So, I just wanted to get on here and do this now because I just got some sleep. I'm feeling pretty good. I normally do this in the morning, but I was like, hey, why not? Let's just get this going now. So I might start doing these lives like this at night or in the evening time after, because sometimes when I get home from work and I'm like rushing around trying to get shit done, and it's sometimes it's a struggle, and that's why I pushed it out until tomorrow. But then, like I said, I went to bed, and I don't have to be at work until 10 tonight, so I still got 5 hours. So I got my coffee. I ate some. My mom made some sort of fruit bread thing for some Jewish holiday that's coming up. And yeah, so anyway, I also wanted to give a little quick announcement. Oh, now I'm yawning. So let me go ahead and do this real quick. The sweater contest, I announced the winners for that. Edit. Just want to. There. And then. File save. So the sweater contest, I announced the winners for that. Everybody who won has been informed. If you guys want, a few people have already told me what they wanted. I think everybody actually pretty much told me what they wanted. We only had 10 submissions this year, so I told Brendan, just pick your top 10 or your top 5, and just do it 50-50, and he did. So yeah, it was a great. He had a lot of fun picking out everything. So thank you to everybody who joined in, who contributed. And then, so last Saturday when Brendan called me, I told him the merch store had. I'm always very transparent about these things with you guys and with him. So I told him, the merch store had about $50 waiting to do a payout. And I always tell him, if you need the payout now, or, if you want, I usually wait until it gets to $100 and then I'll do the payout. Payout is when I say, send me my money, and they send me the money. And it could take like a week or two to get to my account, but I usually wait until there's $100 and then I do the payout option. And then from there, I'll take the money and send it to Brendan's account. And that's, I usually post a screenshot in the group showing that I deposited the money and a screenshot showing the payout amount. This time, Brendan was telling me that how about instead of you doing the payout and just sending me the money to my commissary, why don't you just buy me these drinks that I like to drink? And so I was like, yeah, it's your money, Brendan, whatever you want to do with it. So it's about $90 for the 3 cans of drink that he wants. And so I did that today. So I actually just bought him. Here's the receipt. I'm going to post it in the group. As you can see, I bought the 3 drinks. It came out to $90-something, which is more than what the payout is. But because people are putting money towards 2 people who won prizes were like, put the $20 towards Brendan. So that's what that money is going. Hey, Jinx. Welcome. So yeah, that's just wanted to give that little update, and then yeah, we do have, like I said, if you want to buy merchandise, all the proceeds go to Brendan. one way or another, either to his drinks or to him directly. Yeah, so if you guys want to buy something, I already bought one of these shirts. I'm excited to get it. I bought a shirt and a sticker for myself because I collect stickers, so I'm excited to get my... Hey, Cherie! I'm excited to get my We Can Do It Free Brendan Dassey t-shirt. So, let me actually exit out. But yeah, so that's what the little updates are, and I should be getting postcards, new postcards in the mail soon, so I can start doing that, sending out new postcards. All right, so we're getting to Anatomy of a False Confession, Interrogation and Conviction of Brendan Dassey by Michael Chinchini. We're on page 28, chapter 28, I'm sorry, page 149. And I know I read like a paragraph or two of this, and then I had to stop because the internet guy was here. He came that morning to install my internet, so I had to stop early during that live, so I do apologize still about that, but we'll continue. So chapter 28, Too Close for Comfort. After what seemed like forever, the court that is known as the Rocket Docket in the Seventh Circuit Court of Appeals finally issued its decision on June 22nd, 2017. Hey, Mose. In a Too Close for Comfort 2-1 opinion of 3-judge panel, the Seventh Circuit affirmed the district court's decision. Dassey's so-called confession was coerced and should not have been used against him at trial. And Judge Duffin's reversal of the conviction, more technically his granted of right, stands. The Seventh Circuit decision is 128 pages. Part of the reason it's so long is that there is no state appellate court reasoning to which the court could defer, so it had to analyze everything from scratch. Hey, Colette. The Seventh Circuit explains. The State Court of Appeals in this case affirmed the trial court's determination that Dassey's confession was voluntary and admissible. As his last state court to speak to the issue, it is that court's decision that we review. After noting the requirement to consider the voluntariness of the confession using the totality of the circumstances test, the state appellate court addressed the voluntariness of the confession in 2 short paragraphs. A court has not applied the totality of the circumstances test simply by stating its name. Applying a rule of law does not require much, but it requires more than just parroting the words of the rule. In addition to failing to consider the factors in light of the totality of the circumstances, the state appellate court failed to consider some key factors at all, even individually. It is true that the more general the rule, the more leeway courts have in reaching outcomes in case-by-case determinations. But the generality of the rule does not mean that a state court may forsake it completely. Given that the Seventh Circuit was starting at square one, what factors swayed it to rule in Dassey's favor? The same factors that swayed the district court and every person in the world who is not a police detective or prosecutor in the state of Wisconsin. More significantly, Dassey's statement was not really his statement. It was the interrogator's statement. Sure, Wiegert and Fassbender claimed to want honesty, but that was just the word they used to allow the trial judge and state appellate court to conclude that Dassey's confession was admissible. Hold on. I'm going to do something real quick. There we go. Okay. The Seventh Circuit looked beyond the interrogator's superficial trickery. Dassey quickly learned that honesty meant telling the investigators what it was that they wanted to hear. When they did not like his answer, they told him things like, "Come on, Brendan, be honest." And when Dassey wouldn't immediately change his answer, the interrogators made sure Dassey knew that they, not objective reality, would determine whether he was telling the truth. "I gotta believe in you, and if I don't believe in you, I can't go to bat for you." It was important to Dassey that Wiegert and Fassbender go to bat for him, as the interrogators knew this. As Chapter 11 explained, they convinced Dassey that the prosecutors and sheriff wanted to charge him for Halbach's death. However, Wiegert and Fassbender, his two new father figure friends, were on his side and could protect him, as long as he told them what they wanted to hear. The interrogators used their leverage to shape the confession itself. The Seventh Circuit explains. As Dassey got closer and closer to the answers the investigators were looking for, his statements were rewarded with affirmations like, "That makes sense. Now we believe you." And in doing so, they cemented that version of the facts. But when Dassey deviated from the expected narrative, the investigators either offered no reward, ignored the comments, steered him away, or let him know that they thought he was not telling the truth. In short, as the examples clearly demonstrate, be honest, tell the truth. The similar pleas became code for, "Guess again, this is not what we wanted you to tell us. And now we believe you, and that makes sense," became code for, "That's where we want to hear. Stop right there." The part of the Seventh Circuit's decision that was most enjoyable for me, however, was its debunking of the prosecutorial sophistry that we defense lawyers hear on a frequent basis. It is highly entertaining, for me anyway, to have an appellate court recognize such nonsense and use logic and reason to destroy it. For example, the Seventh Circuit debunked the state's outrageous claims that Wiegert and Fassbender did not make promises to Dassey during the interrogation. The government makes much of the fact that Wiegert started at the beginning of the interview. "We cannot make any promises." But that... Hold on. I'm going to mute. Okay, they're done. I was going to play a video real quick to... Yeah. Alright, anyway, where was I? But that early admonition was countered by hours and hours of subtle and not so subtle declarations otherwise. The death by 1,000 cuts. Moreover, Wiegert's full statement was, "We can't make any promises, but we'll stand by you no matter what you did." What would a reasonable person make of an admonition not to count any promises, followed immediately by a clear, unconstitutional promise? More importantly, what would Brendan Dassey, with his limited intelligence and social skills, think of this admonition linked with a promise? The Seventh Circuit also blasted him for its absurd claim that, except for the one leading question featured in Making a Murderer, the rest of the interrogation was merely a question and answer session without any leading or prompting. Although the government concedes that "who shot her in the head" was the leading question, it characterizes the rest of the interrogation as a litany of open-ended questions. The many examples we have just cited belie that claim, but these are merely a few of many instances in which investigators explicitly told Dassey that facts he was to report. The investigators even told Dassey that kind of language he should use. The state also had the nerve to argue that the physical evidence corroborated Dassey's confession, thus proving its reliability and voluntariness. This is kind of a night is day, day is night argument we defense lawyers frequently hear. The Seventh Circuit saw through this sophistry very well as well. The state also argues that physical evidence corroborated many of the details in which Dassey confessed, but in fact, the lack of physical evidence was the weakest part of the state's case. There was no DNA or other physical evidence linking Dassey to this crime in any way. Not a strand of his DNA in the garage, Avery's bedroom, on the RAV4, or its keys, on any of the knives, guns, handcuffs, or any other relevant place. Despite descriptions of a gruesome killing with stabbing, throat cutting, hair cutting, rape, and a shooting, investigators never found a single drop of Halbach's blood, hair, or DNA in Avery's not-so-tidy trailer and garage. Not on the sheets, mattress, carpets, walls, clothing, garage floor, mechanic's creeper, gun, handcuffs, or bedposts, which we can all agree that nothing shows that Brendan's so-called confession had anything. No, there was no proof in the bedroom. There was no proof in the garage. I wouldn't even argue there was proof in the fire pit, because do we have pictures of the bones in the fire pit? No. We have pictures of a dog standing over a dug up fire pit, but we don't have any actual evidence in the fire pit. Yep, nothing to support it. Even the state tried to wrap itself in the now familiar truth flag, claiming that the contradictions within Dassey's story were not created by Wiegert and Fassbender, but Brendan himself. The state argued, as with many difficult admissions, the truth will not come out all at once, but little by little in its fits of honesty. The Seventh Circuit also rejected this argument, once again relying on critical thinking, something that was absent in Dassey's state court decisions. A careful review of the confession does not reveal this to be a story gaining clarity over time. Unlike the ordinary course of a confession in which the narrative increases its clarity as a suspect reveals more information, this interrogation was just the opposite. Every time the interrogators protested the veracity of Dassey's account or fed Dassey information, his story changed. If one sits in front of the taped confession with a legal pad and tries to sketch out the details and timeline of the crime, the resulting map is a jumbled up, scratched outs and arrows that grows more convoluted and the more Dassey speaks. In fact, despite what the state describes as a detailed confession, it has never been able to map out a coherent timeline of the crime, or to figure out in what order or where many of the events occurred. In summary, the court held that Dassey has successfully demonstrated that the state court decision resulted in a decision that was contrary to or involving an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States. Dassey wins again. So it's closed case, or as Wiegert and Fassbender might say, ball game over, right? Not yet. To say that the wheels of justice turn slowly is a colossal understatement. The glacial pace of judicial system, combined with the state's nearly unlimited resources flowing from taxpayer dollars, means that Dassey's case is far from over. To begin, the state requested an back review of the state Seventh Circuit of Appeals. Rather than just a 3-judge panel, such full court reviews are rarely granted. However, against all odds, the Seventh Circuit agreed to the state's request. As a result, Dassey remains in prison while he awaits the full court's decision, a decision that, as Chapter 27 explained, will once again hinge on the application of bizarre, hyper-technical standard known as the Anti-Terrorism and Effective Death Penalty Act. And even if Dassey wins for a third time in the federal courts, a victory that's far from guaranteed, given his razor-thin victory with the three-judge panel, the state could then petition the Supreme Court of the United States for yet another day in court. Even if the state loses at every turn, it can still retry Dassey, but it must do so without the benefit of his so-called confession. And because there's no other evidence against Dassey, that should spell doom for the state. However, the Seventh Circuit has so far left the door open just a tiny crack. Remember when Wiegert and Fassbender interrogated Dassey at Len Kaczynski's invitation? After Dassey had been arrested and charged, and remember how the interrogators insisted that Dassey call his mother from jail and confess to her on the phone? So his confession would appear to be distanced from and untainted by the government's coercive interrogation tactics. For some reason, the admissibility of the phone conversation was not raised, or at least not decided in the course of appeals process. That's interesting. I never thought of that either. Therefore, in its three-judge decisions, the Seventh Circuit stated that should the government decide to retry Dassey, the issue of admissibility of the May 13th phone call between Dassey and his mother will require a fresh look to determine whether it is the fruit, so to speak, of involuntary obtained confessional tree. It is beyond doubt that Dassey's phone call with his mother is the biggest piece of fruit ever grown on any confessional tree. But remember this, if Dassey wins the en banc review in the Seventh Circuit, this issue will be litigated in the Wisconsin state courts, not in federal courts. So we will, no doubt, be treated to entirely new heights of prosecutorial for a lot of big words. It remains to be seen, however, whether the state court will be able to muster more than 2 short paragraphs of legal analysis en route to its decision, should it be required to weigh in on the fruit of the poisonous tree issue. But all of that is premature speculation. It may all be irrelevant, depending on the Seventh Circuit Court of Appeals does next. And we already know what happens next. I don't know, actually. It says Supreme Court. We're almost to the end, guys. 29, 30. Well, faulty logic. Thank you. Thank you, Cherie. I'll just say that instead of that word. So historic. However you say that. Let's see. So, chapter 29. Law is dead. I won't remember that word, right? I will by this point because I keep saying it and I keep stumbling over it. Now I know it means faulty logic. All right. On the bitterly cold morning of December 5th, 2017, I parked my car, bundled myself up, and battled the strong Wisconsin headwinds as I trudged towards the Center for Science building at Beloit. Sophistry? I don't even know. There I was to speak the psychology professor Lawrence T. White students about psychology-based reform in the criminal justice system. More to the point, I would explain to them the variety of ways that police, prosecutors, and judges thwart the well-intentioned reforms in order to ensure that defendants are convicted of the crimes of which they are charged. Sophistry. One of the topics was Wisconsin's recording requirement for interrogations in criminal investigations. As I explained the different tactics the police sometimes use circumventive that requirement, someone in the class asked for my prediction in the Dassey case. My response, Dassey will lose the Seventh Circuit in back hearing, and more specifically, he would lose because of the bizarre standard of the review set forth in the Anti-Terrorism and Effective Death Penalty Act. Due to the bizarre complexity of the issue, a brief recap is in order. The question for the Seventh Circuit is not whether Dassey's confession was true or false. If that were the point of contention, Dassey would win going away. But strangely, neither will the court be deciding whether Dassey's confession was voluntary or involuntary. Instead, for Dassey to win, the Seventh Circuit must find that the Wisconsin Court of Appeals decision that Dassey's confession was voluntary was not merely wrong, but so wrong that no reasonable judge would have reached that decision. This malleable distinction between what is merely wrong versus what is so wrong was specifically designed to render defense victories, rare, even extraordinarily, at this stage of the process. It's so messed up. So it's like basically it's set up to go for the prosecutors, no matter how you slice it. It's so messed up. Further recall that there is a related issue lurking beneath the surface. It is true that the AEDPA requires the federal court to give tremendous deference to the analysis of the state appellate court. However, in order to do so, the state appellate court must have done some actual analysis to which the federal court can defer. And in Dassey's case, the Wisconsin Court of Appeals never analyzed anything when concluding that his confession was voluntary. Rather, it dispensed with the issue in two superficial paragraphs. To narrow in even further on the precise legal issue, the Seventh Circuit must answer this question. Does the state appellate court perfunctory recitation of some legal buzzwords constitute a sufficient analysis to which the federal court must defer? The three-judge panel of the Seventh Circuit said that it does not. As it previously wrote, applying a rule of law does not require much, but requires more than just parroting the words of the rule. And, as the court also noted, analyzing juvenile confessions requires special care. So applying the rule of law to Dassey's case requires even greater effort and attention to detail. Hey, Nan's Life, welcome. When I made my prediction about the outcome of Dassey's case, little did I know that my words would be put to the test in a mere 3 days later. And unfortunately, my prediction was correct. On December 8th, 2017, in a 4-3 decision, for whatever reason, only 7 of the 9 judges participated, which falls well short of a full panel review. The Seventh Circuit Court of Appeals reversed Dassey's hard-fought victory. Why? Because of the AEDPA's requirement that a federal court must give great deference to the state court's decision, even when the state court's decision is wrong. The majority repeated a slightly variation of the now familiar refrain. The AEDPA was meant to be difficult to satisfy. The issue is not whether federal judges agree with the state court's decision or whether the state court decision was correct. The issue is whether the state court decision was unreasonably wrong under an objective standard. But what about the requirement that the state court perform some actual legal analysis rather than merely parroting the words of the rule in 2 short paragraphs? In a jaw-dropping twist, the Seventh Circuit held when the Wisconsin Court of Appeals jumps to its conclusion that the trial judge was more correct in finding the confession voluntary, it had done enough. More to the point, state appellate court's decisions receive significant deference even if they provide no reasons at all. The majority's mind-boggling decision accomplishes two things. First, it reduces the AEDPA standard, a standard that was, in the first place, designed to render defense victories rare, even extraordinarily, to a new low point that not previously been imagined, let alone seen. As the three dissenting judges stated, the majority opinion attempts to justify this travesty of justice as something compelled by the AEDPA. But AEDPA does not paralyze us in the face of a clear constitutional violation. This court should be granting Dassey's petition for right of habeas corpus and giving the state an opportunity to retry him, if it so desires. And second, the majority's decision essentially relieves Wisconsin's appellate court judges of the obligation to perform any actual legal analysis, the very thing for which they are handsomely paid, with salaries that approach $140,000 in 2017, plus this smorgasbord of valuable benefits. Readers can adapt to the AEDPA like framework of their own and decide for themselves whether these judges are merely overpaid or instead grossly overpaid. To put it another way, consider this. When a state appellate court wants to affirm a confession, defendant's criminal conviction, which of the following options is now more enticing? Doing some actual legal analysis which carries the risk of incorrectly reciting the relevant facts or misapplying the applicable law, thus triggering the AEDPA's merely wrong versus so wrong test, or simply skipping the legal analysis altogether and instead rubber stamping the trial court ruling, thus avoiding the AEDPA entirely and saving a great deal of time and effort in the process. The choice is clear. The state appellate courts can now affirm convictions and avoid reversals in federal court simply by rendering decisions that provide no reasons at all. As a philosopher, Friedrich Nietzsche might have said about such a bizarre state of affairs, law is dead. And as the dissenters on the Seventh Circuit did say, Dassey will spend the rest of his life in prison because of the injustice his court has decided to leave unredressed. Ugh. Sorry, I'm just like, it's just so shitty. It's so shitty. I have no other words to say other than it's shitty. I think I'm going to read one more chapter and then I'm going to call it a day. Maybe two more. It depends on how I feel. Because I have two more chapters and then we get to the next part, which is legal reform. So we can do that next Monday. But so I basically got 4 pages left to read until that part. So maybe I'll just keep going for the 4 pages. But yeah, I mean, we all know what happens at the end of all of this, and it just really sucks. But I mean, it's nice to have somebody break it down in somewhat understanding terms as to why it went wrong or what could go wrong or whatever. Shitty. I mean, a better word, I think, Sheree, would be fucked up, but so I mean, I appreciate the book for what it says. It's just it's really sad that this is the reality of Brendan's legal battles, and that his confessions should have been thrown out. Like, it shouldn't even made it to the level that it made it. The prosecutor should have said, this is not a clear-cut confession. There's so many issues in it. Like, there should have been no reason why Brendan should have even went to trial with that confession. Or at all, because there's absolutely nothing proving that any crime, but based on Brendan's confession, that any crime occurred. And, they have, we keep highlighting this fact, and it's just the truth. There's absolutely no evidence to prove that Brendan's confession happened. Even if you take this stuff like the hood latch and the bullet and the bullet they found and things like that, it still doesn't connect it with Brendan, because there's no proof to show that it came necessarily from Brendan, because they let him say all this stuff. It was contaminated. And there's no, and they didn't even use it against him in court. It's just so crazy on everything that happened and where Brendan's where he's at now. It's just, and the fact, it feels like reading this, unfortunately, because of the, let me read the stupid rule that they never should have put in. I don't know what they were smoking that day to put this in. I don't know what they were like. What is it called again? Add the Anti-Terrorism and Effective Death Penalty Act. I don't know what they thought they were doing. That was so awesome with making that happen, but yeah, no, I'm just like, yeah, I hate that, and I don't understand why they thought that this was a good thing, and I guess I understand at the time. This is why you don't make decisions angry. After the Oklahoma bombing, which was seemed like 30 years ago, I guess they felt like they had to do something, but I would rather somebody sit 30 years on death row in appeals and all that than have this law passed again. It's just absolutely ridiculous that this passed, and it's ruined a lot of innocent people's lives, including Brendan's. It just really sucks. But I'm going to continue. Chapter 30, Stare Decisis. The Latin stare decisis means to stand by things decided. Today, we simply refer to this concept as following legal precedent. What this means is that whenever a court makes a decision, it is bound by its prior decisions, and especially the prior decisions of higher courts. This promotes the even-handed, predictable, and consistent development of legal principles, fosters reliance on judicial decisions, and contributes to the actual and perceived integrity of the judicial process. I agree, Cherie. If it happened to someone they cared about, they would change their tunes. Absolutely. That's why that whole, if it was your son, you'd want something done. And I truly believe that if this happened to Governor Evers or any other governor official's child or family member, it would change. Given this reliance on precedent and putting aside monetarily the hyper-technicalities discussed in the last chapter, many people understandably wonder how the Seventh Circuit's panel of 7 judges could possibly have ruled 4-3 against Dassey. After all, there are numerous court decisions where the interrogators promised and threats were less extreme than Wiegert and Fassbender's, yet the defendant's confessions were considered coerced and therefore not admissible. Why didn't the 7-judge panel have to follow those holdings? The answer is that the doctrine of state decisis has little meaning in real-life criminal cases. The real world, judges can easily invade it by distinguishing prior case laws based on the most insignificant factual details. To illustrate this phenomenon, we will step aside momentarily from Dassey's case to one of my own. I first discovered the uselessness of the stare decisis doctrine as a young lawyer defending a man charged with the simple misdemeanor possession of marijuana. In facts of the case were undisputed. The police saw my client on the street, had the legitimate reason to suspect he possessed marijuana cigarette, watched him go into his home, followed him inside without permission and without a warrant, and then searched and arrested him. Fuck that. Sorry. This seems like an obvious Fourth Amendment violation to me, and when drafting my motion to suppress the evidence, I was thrilled to find a case directly on point. The case even had its origins in, where else? Wisconsin. And it was appealed by all the way to the Supreme Court of the United States. I couldn't have dreamed of finding a better case for purposes of legal precedent. In that case, Welsh versus Wisconsin, the facts were also undisputed. The police suspected a man of driving drunk, learned that he had abandoned his car, went to his home, walked inside without permission and without a warrant, and searched and arrested him. Given these facts that were identical to my case in every meaningful way, our nation's highest court ruled as follows. It is axiomatic that the physical entry of the home is the chief evil against which the worded of the Fourth Amendment is directed. It is not surprising, therefore, that the courts have recognized as base principle of the Fourth Amendment law that searches and seizures inside a home without a warrant are presumptively unreasonable. Prior decisions of this court have emphasized that expectations to the warrant requirement are few in number and carefully delineated, and the police bear a heavy burden when attempting to demonstrate an urgent need that might justify warrantless searches or arrests. Our hesitation in finding exigent circumstances, especially when the warrantless arrests in the home are at issue, is particularly appropriate when underlying offense for which there is probable cause to arrest is relatively minor. When the government's interest is only to arrest for a minor offense, that presumption of unreasonableness is difficult to rebut, and the government usually should be allowed to make such arrests only with a warrant issued upon probable cause by a neutral and detached magistrate. The Supreme Court of Wisconsin let stand a warrantless nighttime entry into the petitioner's home to arrest him for suspected drunk driving. Such an arrest, however, is clearly prohibited by the special protection afforded the individual in his home by the Fourth Amendment. The petitioner's arrest was therefore invalid. The judgment of the Supreme Court of Wisconsin is vacated, and the case is remanded. Good for him. Despite this clear legal precedent, the prosecutor wanted a conviction and therefore opposed my motion to suppress the marijuana cigarette. He argued without articulating any explanation or reason that the police in my client's case were justified in entering the home and that Welsh was indistinguishably on its facts. The trial court judge then turned toward my direction, and our exchange went something like this. Judge, Mr. Cincinnati, me, thank you. I provided a case directly on point. The prosecutor says it's indistinguishable, but doesn't explain why he believes that. Welsh is a case from our nation's highest court. It holds that the police cannot walk into a person's home without a warrant to search and arrest him for a minor offense. That's exactly what the police did to my client. The facts here are not disputed. The police violated the Fourth Amendment, and the marijuana cigarette should be suppressed. Hey, Donna. Judge, well, Mr. Cicchini and Welsh, the police were pursuing a man for suspected drunk driving. Your client, as you conceded, was a suspect of marijuana possession, a suspicion that, you must also concede, turned out to be correct. Me. With regard to the crime under suspicion, that is not in dispute, but that's not the point. Neither is the point that the suspicion was reasonable at the time, and even turned out to be correct in hindsight. The legal test is whether the suspect offense is in a minor offense. If it is, the police must get a warrant to enter the home. And simple possession of marijuana is a misdemeanor in our state, a lower end misdemeanor at that. It carries a lower penalty than judge. Well, the court's language you were referring to seems like dictum to me. It's not really part of the court's holding. Me, the Supreme Court of the United States is not going to set down a rule of law that is so limited in its application. The test is whether the suspect offense was minor. If it was, then the entry into the home without a warrant, the chief evil against which the wording of the Fourth Amendment is directed, was illegal, and the evidence must be suppressed. The Fourth Amendment protects everybody, not just those suspected of drunk driving. Judge, well, I see significant differences. Me, Your Honor, this may be helpful. The court even enumerated many types of suspected crimes that would be too minor to justify a warrantless entry. For example, the court, judge. All right, I'm prepared to rule. The case cited by the defense is applicable only by warrantless entry into the home to arrest a person for suspected drunk driving. In our case, the defendant was suspected of possessing an illegal controlled substance. Welsh is indistinguishable, whatever that means, on those grounds, and the defendant's motion to suppress the evidence is denied. Oh my God. Right, Cherie? You're like, what? I agree. It's the same thing. And I don't care what he has in his house. You do not have the right to enter in a civilian's house without a warrant. That's our constitutional right. That's bullshit. It really wasn't easy for a trial court judge to bypass the doctrine of the state stare decisis, and even the United States Supreme Court, all for the purpose of a stinking defendant who possessed a marijuana cigarette. And even if my client had been suspected not of pot possession but of drunk driving, as the defendant in Welsh, the local judge could have found other significant differences in which to hang his hat. For example, in the Welsh, the police entered the defendant's home at night. In my case, they entered during the daylight hours. In Welsh, the door was locked, and the police ordered the defendant's minor child to open it so they could enter. In my case, the door was shut but unlocked, so they opened it themselves and then walked in. The list of insignificant factual differences goes on, all the way down to the defendant's hair color. I would say suspect drunk driving is much more dangerous. Yeah, I do too, Cherie. And it still doesn't matter, though. It's still what did he call it again? Minor offenses. There's still two minor offenses. They entered in without a warrant. They did an illegal search. It's completely and totally unconstitutional. I can see you. Hi, Donna. So it really upsets me that this happened to this person over a marijuana cigarette, because no matter what it was, whether it was a gun, marijuana cigarette, even if it was a bomb or something more serious, they needed a warrant before entering the house. And I guarantee you, if it was something serious, if it was something like actually like serious, like a bomb, they would have gotten that warrant because they wanted that to stick better. You know what I mean? Returning then to Dassey's case, this type of judicial chicanery was also on full display, but for more at stake. To begin, when the three-judge panel of the Seventh Circuit ruled in favor of Dassey by holding that his confession was coerced, it analyzed legal precedent extensively. It discussed at least 7 cases in depth and cited more than half a dozen others before reaching its decision. How then did the subsequent panel of 7 judges respond to this analysis of pre-sentence? Much like the trial court judge in my marijuana cigarette case, it simply distinguished the legal precedent that it did not wish to follow. It then declared that Dassey simply has not pointed to Supreme Court precedent that mandates relief under these circumstances. The Supreme Court has not found a confession involuntary in circumstances like Dassey's March 1st confession, then elaborated by discussing 2 cases. First, the majority of the 7-judge panel believed that the Bolden versus Holdeman was indestructive. The defendant in that case was older than Dassey and was interrogated for a short period of time, 2 factors that would seem to weigh in Dassey's favor. However, the majority of Dassey's panel found that particular case more troubling than Dassey's, in part that the defendant was interrogated from 10 p.m. until after midnight after several hours in custody. And because the court in that case held that the defendant's statement was inadmissible, then Dassey should be inadmissible too. Second, the majority of the 7-judge panel also relied on Fair versus Michael C. The defendant in that case was the same age as Dassey, but had a higher IQ, and unlike Dassey, had prior experiences with the police. These 2 factors would seem to weigh heavily in Dassey's favor. However, the majority of Dassey's panel found that the particular case more troubling than Dassey's because the defendant claimed he feared police coercion and pointed out that he wept during the interrogation. And because the court in that case held the defendant's statement was admissible, then Dassey should be admissible too. The 3 dissenters on Dassey's 7-judge panel were flabbergasted by this annihilation of precedent, as I was when my trial court judge rubber-stamped the warrantless police entry into my client's home to search for his marijuana cigarette. And 3 dissenters in Dassey's case wrote, the majority concedes that AEDPA does not require a nearly identical factor pattern to find that a decision involved an unreasonable application of law, but that is an essence in which the majority has demanded, in arguing that even non-AEDPA cases have found confessions voluntary under similar circumstances. The majority cites 2 decisions, but it concedes Fair versus Michael C. is critically different. Michael C. was one of the average intelligence and had many prior interactions with the criminal justice system, while Bolden versus Holman may superficially appear to be more similar to Dassey's case. It is dubiously relevance given to the fact that it was decided, along with Michael C., decades before the Supreme Court instruction lower courts to recognize the unique psychological vulnerableness of youth stemming from their incompleted neurological development. The Wisconsin Court of Appeals failed to apply in any meaningful way at least 3 principles that the Supreme Court has clearly established. 1. Special care for juvenile confessions. 2. Consideration for the totality of the circumstances. And most importantly, 3. Consideration of the totality. Wait, I already said that. 3. Probation of psychologically coercive tactics. This led to the kind of extreme malfunction in the adjunctiation of Dassey's case for which the law provides a remedy. By turning a blind eye to these problems, the majority has essentially read habeas corpus relief out of the books. In short, with the Latin phrase stare decisis sounds impressive and gives law school professors something to wax eloquent about to the impressionable first-year law students placed in their charge, it offers a criminal defendant little to no help in the real world. The doctrine completely fails to construct judges at any level of the court system, from state-level trial courts all the way through the federal courts of appeal, and can be sidestepped merely by pointing to the smallest irrelevant factual difference between cases. In this way, the law is no different than any other realm of life. A person, here a judge, decides the outcome he or she wants to reach, and then cherry picks the information, here from previous court decisions, that supports the predetermined conclusion. All other evidence be damned. Or as the great Ambrose Bierce wrote more than a century ago, under the doctrine of stare decisis, a previous decision has whatever force and authority a judge may choose to give it, therefore greatly simplifying his task of doing as he pleases. Alright, last chapter and then I'm done for the day. Chapter 31, What If? An incredibly long sequence of events had happened for Brendan Dassey to be convicted of murder without an eyewitness, single piece of evidence, or even an accusation against him. An even longer sequence of events had occurred for that truly bizarre conviction to eventually be upheld by a flip-flopping federal court of appeals. It is interesting to imagine how Dassey's life would have turned out if just one of the things that the long chain of casual events had been just the slightest bit different. For example, what if Stephen Avery's wrongful conviction in the Penny Bernstein case in the mid-1980s, Dassey's parents had taught him never to speak to law enforcement without an adult present? What if they had taught him simply to say, "I want a lawyer," when questioned by a government agent? Even without such parental wisdom being imparted, what if Dassey had simply thought to tell Wiegert and Fassbender that he wanted his mother present when they questioned him about Teresa Halbach's murder? If Barb had been there, or would have the interrogators have used the same threats and false promises? Or would they have developed a completely different approach to the interrogation and it would have worked? And even without that, what if when Wiegert and Fassbender first yanked Dassey out of his classroom for a non-custodial interrogation, Dassey had said, "I don't know anything about how Halbach died, and I'm going back to class now"? Or if Dassey had decided not to speak to an investigator simply because he knew they were trying to gather evidence to pin on his uncle, Stephen Avery, for the Halbach murder? In other words, what if Dassey's sense of loyalty to his uncle had overcome his reluctantness to tell two adult authority figures to pound sand? It is also interesting to think about the lawyers. What if the Wisconsin State Public Defender, SPD, had been paid more than 40 hours per hour? 40 hours an hour? He's complaining? Wait, have been paid more than $40 per hour? How much do lawyers get paid? I get paid $14 an hour. If I got paid $40 an hour, holy shit. Are they complaining because they get $40 an hour? Sheree, how much do lawyers get paid? Is that low? What if the Wisconsin State Public Defender had been paid more than $40 an hour, a rate that is still in effect in 2018 and is the lowest in the country, to defense lawyers who defend homicide cases? I'm sorry. $40 an hour? That's a lot of money an hour. Is that And that's low to them? That's more than a teacher gets paid. Hold on. $40 an hour? That's $1,000. That's $1,000. That's $1,600 a week. That's more than I get paid in a month. Dude, I'm telling you right now, if I got paid $40 an hour in any job, I would get paid $75 an hour for a felony working for them. They get paid $75 an hour? Oh my God. I'm in the wrong business, I tell you what. Maybe I should be a lawyer. I would be happy with $40 an hour. That they get paid $40 an hour is what I get paid in 1 month of work that they get paid in 1 week. Holy cow. That's a lot of money, Cherie. And they're I'm sorry. I guess that is low end in the in the land of lawyers. Like, maybe that is low pay, but like, as somebody who works for I get paid less than McDonald's workers in my area, right? Like, I can go to McDonald's and work $16 an hour. I get paid $14 an hour to be a caregiver. I get $14 an hour to take care of human life, and I can get $16 an hour flipping burgers. And no disrespect to anybody working at McDonald's, you got to do what you got to do in life to get by. But if they were like, oh, you can get paid $40 an hour and that's low end, I would be like, I'd take it. Are you kidding me? Well, I hope you get paid well for yours. I would imagine a lot of lawyers get paid salary these days. I don't know. But oh my God, like, I have a very hard time. I'm sorry I know that he's trying to make a point saying that the public defenders get paid low end in Wisconsin. But I have a hard time feeling sorry for $40 an hour. I'm sorry. But anyway. So, like, what? $40. What if the Wisconsin State Public Defender had been paid more than $40 an hour? Must be nice. Right? That is still in effect in 2018, and then it's the lowest in the country. I could see why you would be angry, though. I will say that. As somebody, like, if you were being paid the less amount in the whole entire country, that would be pretty insulting. I understand that. So, but still, that's $40 an hour. If they could just give it to me. Defense lawyers who defended homicide cases. If the pay had been higher, would the SPD have been able to appoint a different, more Kaczynski to represent Dassey? And how would that have affected the eventual outcome in the case? Regarding Kaczynski, what if he had talked to Dassey and investigated the case before deciding on his defense strategy and sharing it with the media? What if he had been trained in, or at least knew about, the phenomenon of false confessions? And what if, on appeal, Dassey's appellant lawyer had simply alleged that Kaczynski rendered ineffective assistance of counsel, instead of their claim that he had conflicted of interest, a novel theory that was rejected by the district court and the 3 and 7 judge panels of the 7th district. Given what Kaczynski did and didn't do in the case, would arguing ineffective assistance of counsel would have been more persuasive to the 7th Circuit than the claim that Dassey's confession was coerced? Or would the outcome have been the same either way? That's in New York. Wow. I just hope you get paid well for your job, Cherie. I do. Eventually, Kaczynski was removed from the case, and the SPD appointed 2 more experienced lawyers for Dassey's trial. But those lawyers have been viewed as more as defending a murder case than a false confession case? What if instead the trial lawyers had used an expert witness to educate the jury about the interrogation, a demonstrated link to false confessions? Would that expert have made a difference in the jury's decision? Or was Dassey's ship sunk either way? What if the decision court, or what if the Wisconsin Court of Appeals had written only one paragraph instead of two, when, in jumping to his predetermined conclusion that Dassey's confession was freely and voluntarily given? Would that still have been significant analysis to which the federal courts must defer? And if the Anti-Terrorism and Effective Death Penalty Act was never signed into law, would the Seventh Circuit have ruled in Dassey's favor if it didn't have to apply that bizarre so wrong versus merely wrong standard of review? Or would the seven-judge panel, like the State Court of Appeals, still have found a way to rule against Dassey? What if the Seventh Circuit had used a true full panel review of 9 judges instead of 7? That is, what if Judge Flem and Barrett had also participated in the 7th en banc hearing of Dassey's case? How would they have voted? And if Judge Richard Posner hadn't retired from the Seventh Circuit shortly before the courts issued its decision, how would he have voted, and would his vote have made a difference? And of course, the biggest remaining question is this: what if the Supreme Court of the United States agrees to hear Dassey's case? Getting the attention of the nation's highest court is a long shot, to be sure, but while it might be too late for Dassey, check the postscript section at the end of the book for an update. What types of legal reforms could save under defendants from similar fate? So that's the last of this, and then goes on to the next part, which is legal reform. I often think of what ifs all the time in this case. Like, what if, like, for instance, during Making a Murderer 2, I noticed Steve Drizzen rewatching it again. He said that he was actually watching Brendan's case in 2007 in real time through the news and all that, because it was very, because Brendan's case was the first case where they recorded a juvenile during interrogation. He was the first one. So that was, as somebody who works in interrogations of minors, and my mom must be cleaning the oven, or the house is on fire. As you know, he's watching it in real time, and it's making the news in the false confession and wrongful conviction, the minors world. So Steve Drizzen is watching this. I often do the what if. Well, what if Steve Drizzen actually tried to contact Brendan's lawyers and try to offer assistance because he saw this train wreck happening? You know, what if they did reach out? Like, Jerry Buting apparently was working on some board or whatever, and Steve Drizzen, hey, under your scars, you're here. You know, and Steve Drizzen was participating in something, and they were talking about whatever. What if Jerry Buting actually got Drizzen to at least appear for Steven's side of things? You know, I don't know. What if, you know, and another thing is, I heard a rumor once that Jerry Buting and Dean Strang were actually considering to be Brendan's lawyers, and like they were considering it before they decided to put Steven on, and then Steven hired them on. So the question is, what if they actually became Brendan's lawyers? Would that have made a difference? You know, it probably would have made a huge difference. But then where would Steven be? I don't know. Maybe he would have gotten, not saying that Jerry and Dean were bad lawyers, but maybe Steven would have gotten lawyers that would have been more effective for him. I don't know, there's just like a lot of what ifs in this case that can just literally drive you crazy if you let it. And I really try not to think about those, because even in my own personal life, I think, like, what if I was 19 at the time of all this happening? What if I was paying attention to the news and I actually, like, was paying attention and I saw this happening, and I could have been there earlier for Brendan as a friend, and written to him, and he wouldn't have spent all those years alone so much, it's stuff like that too that it actually really hurts the heart. So yeah, they missed a number of things calling witnesses. They could have done so much with Brendan's case to disprove. Would it have made a difference, though? Because I think we can all agree the state wanted to convict Brendan and Stephen no matter what. Like, there was even talk of that the sheriff was having pizza and meals with the jury during breaks. That's not appropriate. So God knows what actually was going on in that. So there's so many what ifs, and I try to focus on the now. Like, we can make it better now. But it's an interesting chapter, and I think the number one thing is that and I think the biggest what if is, what if Barb and Pete taught their kids don't talk to the police without a lawyer? That's a good point. Conflict of interest. Yeah. What if what if Brendan knew that right off the bat? I'm not going to talk to these police officers. They screwed over my uncle the first time. Why would I want to talk to them now? Would Brendan may not be in this mess at all, but there's just a lot of, yeah. I think that's why it's important, though, that we teach our children and our youth, don't talk to police without a lawyer. Even a parent, even to be like, oh, don't talk to police without your parent. No, it should be without a lawyer. Yes, you should call your parent, but we need to educate parents that they need to get lawyers, and we need to educate children that to not talk to the police ever. Police are not, I know that they're supposed to be like, police are your friends. They're there to help you. The police are not your friends. They're not there to help you. They're there to, investigators, I should say, but even police officers. They're there to do their job, which is to secure a conviction. And they don't care who they railroad. You cannot talk to a police officer without a lawyer, period. Always lawyer up. Yeah, that sucks and it's expensive, but look at how much money and resources it's now taking to get Brendan out. Yes, a great miscarriage of justice, Facebook user. Mystery person. I can go check who it is. But yeah. So that's all I have for today. I'm going to wrap this up and then probably do some junk journaling or whatever. Thank you all for being here. Yeah, if they stopped there, Brendan, might have had a chance, but they didn't. So just remember, oh, it's Roxana. Hi, Roxana. So just remember, merchandise is available, and like I said, I just bought those 3 canisters for Brendan using the merch money, which I'll make a post in the group here after we're done with the live showing that. And yeah, you know, we just got to keep doing what we're doing. Yeah, and I'm sorry for stumbling over these words, these big word, fancy lawyer words that I didn't go to school to learn. So, but thank you for being here, and I hope that if anything, it's been interesting, and I'll send you a message in PayPal a bit toward Pete's Gas and Snap. Oh, you don't have if you want to. I will gladly forward any money to Brendan, and I'll try it with Pete. If you, yeah, I'll message you about that. But yeah. So next Monday, I'm gonna set the live for in the morning, but I'm gonna base it off of if I go in the morning or in the evening again, because the evening worked out a little bit better for me. It was nicer. It was nicer that to sleep before doing this, because you know, coming off from a 12-hour shift and then doing that just didn't sound appealing to me this morning. So that's why I was like, I'm gonna go to sleep, and I'm kind of glad I did. So we'll see how next Monday goes, and then I should be good to go Saturday. I don't have plans outside of sleeping in Saturday. So this Saturday I should be able to continue on the post-conviction stuff, and then Friday we should be doing the Positively Brendan, and I will be back this Wednesday because like I said, now that Ginger's doing good, the roof is done, everything's fine, so I should be able to get back on my schedule of things. So, but thank you for being here. Yes, let's keep talking about it, keep spreading awareness. As soon as I get more postcards, I'm sending out a whole bunch to people I already know, have addresses for, but please let me know if you do want them, or if you don't want them anymore too. Somebody actually messaged me, which is fine. I'm not upset about it. But also I want to say though real quickly, if you guys want to continue and you find that you don't have the money for stamps, but you still, let me know. I don't mind sending you the money for stamps, or sending you stamps, I should say. So, we're all a team, so, we got this. But yeah. All right. Well, I hope everybody has a good day. And also, I'm going to be doing, real quickly, just also to let you guys know, I've been changing around some videos on our channel here. I'm trying to get more YouTube-friendly songs. So you'll be seeing some changes and some things, definitely. But anyhow, have a good day, everybody. And let's keep fighting for Brendan.
It means everything, to have a family that loves and supports me no matter what, and they always have my back,
Yeah, and it really is heartening to know that so many people care and still care. And what would you tell people that want to get involved, that have seen your story, who didn't really have any idea of what goes on in our justice system, but now they do? Is there anything particular that you could advise someone?
Just keep fighting for me, and keep showing your love and support.
We saw things that I think have never been seen before in a court of law. I can't think of another case where a defense attorney and his investigator plotted to pressure their client to plead guilty to a case that in which he was expressing his innocence.
That tape was somewhat disturbing, I think.
It was extraordinarily disturbing, and Michael O'Kelly is a seasoned investigator, and I believe what he did to Brendan Dassey traumatized him. The first question you have to ask yourself is, do you spend the rest